David Sobel. I'm a real estate attorney here in Michigan. And today's question comes from Lisa, who wrote last week that her mortgage company had set a closing for her new home on a Friday, but that she wanted the documents to be first reviewed by a real estate attorney. When she told her loan officer that, the loan officer said that it was not necessary because their loan documents were federal mortgage documents, and so they're really legally compliant already. So that's what Lisa said. And she also said that she feels it is appropriate to have a real estate attorney review the closing documents, but that the loan officer had not sent the documents to her. So what she wants to know is what she should do, because she doesn't want to jeopardize the loan closing and her loan. Well, it's a really good question, Lisa, and a big concern. First of all, I'm going to tell you I agree, of course, that when you are closing on what is arguably the most significant and probably the most expensive purchase that you'll ever make, that you should have a real estate attorney review your mortgage agreements as well as your purchase agreements. I mean, your mortgage agreement you're going to have for the next 15 to 30 years, and you definitely need to have an attorney review those. So you should get a closing package, as it's called, really from your loan officer without any issues. But first, it should be noted, Lisa, that you should always involve your real estate attorney at the very beginning of the home purchase or home buying process. And, that includes having the purchase agreement and the loan application reviewed before you sign any documents. Now, it may sound self-serving, but, not a week goes by where I don't get a call from an unhappy client or actually an unhappy seller or buyer who becomes a client who now wants to get out of their contractual obligations. It's the provisions of the purchase agreement actually where most of the problems in a real estate transaction actually occur. So legal opinions on the contract terms and their legal consequences can really only be addressed by a competent attorney who specializes in real estate. It's not going to be your realtor, it's not going to be your loan officer, and it's not going to be your title agent. Only a real estate attorney or an attorney can give you a legal opinion. So here's an example. Many people who purchase a property in as-is condition will believe that they've forfeited their right to have a property inspection. And the provision in the purchase agreement says you're buying the property in as-is condition. But you as the buyer really don't forfeit the inspection. But many real estate sales agents won't tell you that. And they're motivated by commission to get your transaction to close. And it's easier to do that without having the buyer have a problem after a home inspection. So many a buyer forgoes their home inspection because of the as-is clause, and then they live to regret it later on. So you should still have the right to inspect the property, maybe for structural issues, etc. And if you don't like it, you can move on. But once you know what's going on with the property, then you have to take it as is. Well, attorneys will read through the purchase agreement to ensure that the contract terms meet the client's expectations in a real estate transaction. What we do as real estate attorneys is we review timelines, sales contingencies, we look at warranties and representations of each party. And if we spot a legal issue in the contract, it's our job to confer with our client and let them know, hey, this is going to be an issue for you, or was this what you were expecting? Now, at the time of the closing, attorneys need to receive what's called an attorney's package, and that should contain all of the seller and buyer closing documents. It should contain the mortgage documents and also the title documents. And usually these closing documents consist of about 100 pages of documentation, and the content is actually presented in 10-point font, usually on legal-size paper at the closing. So rarely do purchasers have time to review all of the legal representations made by either both the mortgage lender or by the title company. Nor, do they understand all of the legalese contained in the mortgage documents or in the title paperwork. That's what an attorney does. It's our job to review all of these documents and that control the transaction. And then what we do is we make sure that they are in line with the initial representations and expectations that were made at the time of the purchase agreement. So, if you're taking a deed we want to know what type of deed are you taking? Were you supposed to get a quitclaim deed, a warranty deed, a covenant deed? I mean, we also want to know, is the legal description marketable, or are the taxes prorated properly and in accordance with the purchase agreement representations initially? So we confirm that, and we also confirm the terms of the mortgage. Are they the same as the terms contained in the initial good faith estimate of the closing cost? Were you getting the right loan? Was it an adjustable rate when it should have been a fixed rate? These are just a few of the many considerations that lawyers like myself make when we review your documents. So despite what the loan officer is telling you, the loan says, you do need to always have an attorney review your closing documents. Okay? My name again, David Sobel. If you have any other questions, you're definitely welcome to give me a shout. Our phone number is 888-789-1715. I can also be reached at www.provenresource.com. And just real briefly, get any questions that you have or any comments, concerns, please let us know and leave comments in the comment section of the video. Thanks again for watching.